There was a really important Supreme Court case yesterday with oral arguments that we need to dive deep into. The question before the court was this: can the government, especially the US federal government, work with internet companies, pressure those companies, and induce those companies to censor specific forms of speech that the government could not itself censor directly? It's one of the most important questions of our time because it's been happening at a rampant scale, far greater than what anyone even imagined several years ago. I wrote one of the first articles on this several years ago. Those arguments now found themselves in front of the Supreme Court. And at least based on the media's reporting of it, the court was skeptical of those arguments. But let's go into a little greater depth of what's really at issue. The basic question of the plaintiffs, which are certain Republican states that are challenging the federal government's use of its power to pressure internet companies to censor speech, is whether the government can actually do its dirty work through the private sector. And it's a longstanding constitutional principle that the government cannot use private actors indirectly to do what the government cannot do directly through the front door. And that's exactly what it's been doing. The government has been using a combination of threats and inducements, sticks and carrots, to be able to get social media companies to censor constitutionally protected speech, so-called misinformation about COVID-19 or the vaccines, or even certain forms of hate speech that were deemed outside of the Overton window of what really could be discussed on the internet. And this is no longer, as it once was described, a conspiracy theory. After Elon Musk took over Twitter, after we've seen the release of documents that came out in these discovery, the reality is it's actually been far worse than anyone ever envisioned. The only question that remains is that behavior unconstitutional? Here's why it is. We have a longstanding tradition in this country that says that if the government can't do it directly, it can't do it indirectly through the back door either. That if it is state action in disguise, the Constitution still applies. Two of the most relevant cases that came up in the oral arguments are first Bantam Books, which is a case in which there was a prosecutor who effectively pressured a bookstore owner to take down a book that the prosecutor didn't want the bookstore owner to sell. Well, when a customer wanted to buy that book and the bookstore owner then refused to sell it to him, what the Supreme Court found in that case was that, you know what, that wasn't the action of just a private bookstore owner because he was acting on the basis of a threat from a prosecutor. So if the government threatens a private actor to do something that the private actor wouldn't have done, that isn't the action of a private actor. It's the action of a state actor. And if it's state action in disguise, the Constitution still applies. That's what the court found in Bantam Books. Now, it's not just threats, it's also inducements. That's another core holding of the court in a different case involving the railroads. Okay, so in the war on drugs, what the government wanted to do was to be able to search and seize drugs off of any person, but there's this pesky little problem that gets in the way called the Fourth Amendment, which says that the government needs a warrant to engage in a search or seizure of a person. So the government tried to get creative. What'd they do? They passed a special form of liability immunity. And if that sounds familiar with the tech companies, yes, it does. I'll come back to that in a minute. But the government gave to the railroads here a special blanket of liability protection that said that we, the government, aren't going to search or seize drugs off an individual person, but we're going to pass a law at the federal level that says that you cannot be sued as a railroad operator if you happen to, as that private company, search an employee or a passenger to see if they have drugs. So it's not the federal government doing it, it's just a private company doing it. And again, the Supreme Court found that just as you couldn't use threats in the case of Bantam Books, you also could not use carrots, such as a special form of liability immunity, to be able to get that private actor to do what the government couldn't do directly under the Constitution. Well, what do you know? The government's not doing just one of those things, it's doing both of those things with social media companies and internet companies, at least over the last 5 years. A combination of those threats: we're going to regulate you, we're going to break you up, we're going to have punitive financial consequences for you. The very institutions that are regulating these agencies are the ones pressuring them to take down speech. Lawmakers on Capitol Hill browbeating those tech CEOs, saying if they don't actually censor Donald Trump, this actually really happened. If he fails to accept the results of the last election, then there's going to be consequences for those companies. When those companies then go do the bidding of those congressmen or those senators or those deep state actors, that's not the action of a private company. And they're also using those inducements because, just like for the railroad providers, there's a special form of immunity, a blanket of immunity called Section 230, specifically Section 230C2, that provides a special form of liability exemption from being sued under state laws if a social media company removes otherwise constitutionally protected speech. That's what the law says. See, there are state laws in red and blue states in this country that prevent political discrimination by companies, including internet companies. But what this law says at the federal level, Section 230C2, is that those companies can't be sued under those state laws even if it's an internet company taking down otherwise constitutionally protected speech. Exactly what's at issue in the railroad case, the government using that private actor through a carrot, through an inducement to do something through the back door that the government couldn't do directly. That is a cardinal constitutional violation. That's really what's at issue. Now, in the mainstream reporting of those oral arguments made before the Supreme Court, they said that they were skeptical of the arguments. In reality, here's what the Supreme Court was skeptical of, especially the liberal justices who asked some skeptical questions. What they really were skeptical about was the standing. It's a procedural argument. The standing of the plaintiffs who were attorneys general from certain red states. They said that those particular plaintiffs had not actually been harmed. And generally in law, it's a concept that in order to have standing to bring a case, you had to have had harm in order to bring that case in court. That's what the liberal justices were skeptical of. So the shame here could be that the narrative could get written, even if the liberal justices on this procedural ground of standing reject this case, actually impugning otherwise valid constitutional arguments. And so if that happens, it's really important that plaintiffs who were harmed, people who were censored or shadow banned at the behest of the government, bring that same case instead. And this is why it's important for us as patriots and constitutionalists to see through a lot of the media reporting about how these Supreme Court cases get decided. Because if that was just on procedural grounds, it doesn't negate the hard truth that still, for the people who are harmed, they do have a case against tech companies to say that it wasn't the behavior of a tech company, it was the behavior of the government all along. And that's the most rampant form of backdoor illegal censorship taking place today. That's why I felt the need to explain it. The mainstream media, as they often do, did a god-awful job of it. And for one of the most important Supreme Court cases of our lifetime, we deserve to see what the heck is actually going on.